We've formed the quorum, and it's the appointed time already. Bills Committee on Private Columbaria Bill, the 8th meeting will start now. We will continue with the clause-by-clause scrutiny of the relevant provisions. In the last meeting, we've completed up to page C3436, which is start from clause 21. I am not going to introduce again the government team joining us. You've got a list of their names with you in front of you. So when they're settled, we will start the meeting. The Principal Assistant Secretary is not here yet. The Deputy Secretary, shall we get started now? All right. Clause 21, and that is on page C3436, and that has to do with subdivision 2, applications in respect of pre-Bill Columbaria. 21. Application concerning pre-Bill Columbarium time limit, evidence of cash interment layout and ash interment quantity as at bill announcement time and plans. P.S. Ms. Wong. Yes, thank you, Chairman. Last time we are finished with C3436, and now we are on C3436 and 3437. By way of background, last time, at the beginning, the Bills Committee asked about certain provisions which would take effect 3 months after the enactment date. So we are now continuing with discussion on provisions which will take effect 3 months after the enactment date. Let's move on to, let's look at subdivision 2, and that is has to do with applications in respect of pre-Bill Columbaria. Clause 21, application concerning pre-Bill Columbarium, time limit, evidence of cash interment layout, and cash interment quantity as at bill announcement time. Time limit and also plans to be submitted. Clause 21(1), it says that an application for the issue of a specified instrument in respect of a pre-Bill Columbarium, and that includes the license, exemption, and the temporary suspension of liability, TSOL. The application must be made after the expiry of 3 months beginning on the enactment date, because in the first 3 months, the licensing board has to be established and preparation works have to be done. And the applications must be made before the expiry of 6 months beginning on the same date. So that is clause 21(1). 2. So they can make applications from the 4th month to the 6th month, but then for reasons listed here, which make the licensing board believe that there are reasonable grounds, the licensing board can consider an application made out of time. There are 2 conditions to be met. 2A, the applicant has a reasonable excuse for failing to make the application within the specified time. And B, in all circumstances of the case, the licensing board considers that it is just and equitable to consider the application. And then we move on to 3, clause 3. An application for a specified instrument in respect of a pre-Columbarium, to which section 14, and that has to do with the license, and section 15 do with exemption, and 16 application for TSOL. And also Section 4 of Schedule 2, which has to do with non-compliant structures. And these are the provisions relating to the non-compliant structures. On these matters, the following particulars must be furnished for the consideration of the licensing board, and those include A, the ash interment layout as at the bill announcement time, and B, for an application for the issue of or renewal of a license, the ash interment capacity as at the bill announcement time. In other words, the maximum number of ashes or niches that can be accommodated. So that's for license. And C, for an application for the issue or renewal of an exemption, or for the issue or extension of a temporary suspension of liability, the ash interment quantity as at the bill announcement time. The quantity has to be specified. As we explained before, we will be very stringent in controlling the quantity of ash interment. So such information has been to be provided so that we can take the appropriate enforcement action. D, the extent of occupation of land as was necessary for or ancillary to the operation of the columbarium as at the bill announcement time. The extent of occupation of land will be limited. E, the fact that any structures necessary for or ancillary to the operation of the columbarium existed as at the bill announcement time. We have to know such information. F, for an application for the issue of an exemption, as you can recall, we take the 1st of January in 1990 as the cut-off date. So the first date on which a set of ashes was interred in a niche in the columbaria, or the first day on which an interment right in respect of a niche in the columbarium was sold. So can we pause here? Well, the provisions are quite lengthy, so can we discuss this part first? Any question? Ms. Sit-Ho. Thank you, Chairman. Well, there is strict control on the application period after the expiry of 3 months on the enactment day and before the expiry of 6 months, so 3 months. If you look at sections 15 and 16, you said that you require certain information, a full set of information be provided. With regard to the first date on which a set of ashes and also the capacity, well, such information can be provided easily. But then for section 16, it says that they need to an authorized person to prove that they are structural or okay in terms of their fire safety prevention measures and so on. And also the proof of land planning from the Director of Lands has to be furnished as well. So if the columbarium has to fulfill the requirements on 1516, how many organizations do they have to deal with and get information from? So can they do that within such a short space of time? Well, of course, I understand that you don't want people to abuse the situation or try to expand their operation within this window or vacuum period. But conversely, you may have to ask them to get proof from authorized persons and government departments. Do such government departments have a time limit for providing the relevant information? Also, for these authorized persons, are they in good supply in the market so that they can provide the information in a timely manner? Perhaps all these government departments and authorized persons have to get preparation work going now. So let me try to explain the procedures a bit. So it's non-pre-bill Columbaria, well, they are not covered by this 3-month period. So there is no deadline or application period for these non-pre-bill Columbaria. Now, sections 15 and 16 have to do with pre-bill Columbaria. And they first have to try to apply for the TSOL, and it extends for 3 years plus 3 years. And at that time, with regard to details like lands and buildings requirements, they have to deal with them in this period. Well, it is not difficult for them to get the TSOL. What they need to do first is to show that they are structurally safe. I'm sure that you agree that that is very important. Second, if there is occupation of government land, then they have to sign a declaration and lodge it with the director of the lands department to claim that they will not be engaged in adverse possession. Say, if they sign that declaration and they adversely possess the land, then we will raise that with the judge or the court. We all understand that the public would try to implement the licensing system ASAP. They don't want us to procrastinate or delay. Well, they can actually make the application from now up to the licensing scheme is in place. They can do all the preparations now. As we explained, the licensing board can also make applications which are not made in time.
If the person has grounds to convince the board to consider the application out of time. So we believe that allowing them 3 months to apply is reasonable. Chairman, I think the Deputy Secretary has said that they should do it now, or you can give them an exemption subsequently, even if you were to put in the application, out of time. So you need to have the right measures in place. First of all, you have to inform the existing operators. That is, if they're afraid that they don't have enough time, they should, get started now. Just fire safety alone, I think it will not take very long for the inspection to take place, but it may require them a lot of time for the operator to rectify any anomalies identified. So if there should be any problems to be fixed, I think 3 months may not be enough. And the operator may not be able to comply with the requirement of Section 16. For example, that an authorized person would certify that the premises is in compliance with fire safety requirements. So to satisfy the requirements in Clause 21, and I'm not talking about the TSOL. For that part, I'm sure the operators can comply very quickly. But when they need to put in application, they have to satisfy the fire safety and other safety requirements. If they don't operate, and if they are not able to operate in time, but then the ashes of many deceased persons may be affected. And many members of the public may also be affected as a result. I think the TSOL simply certified that there is no safety issue. But then the structures in the building, I think if the operator engage, a professional to give evidence and subsequently they obtain the license, during the 3+3 months period, they can still, carry out all those works which are required to be done. Could you give us a paper, give us details about how much time will be allowed given to the operators? Mr. Kenneth Chan. In respect of 21(2)(a), it says that if the applicant could put in the application before 6 months have expired, that would be allowed so long as he provides for a reasonable excuse. So I'd like to ask the Bureau this question. Ms. Ho had tried to come up with some scenarios, for example, that the government may not be, working, operating expeditiously and so on. That could be a reasonable excuse. The department concerned is being slow, or that the preparation to satisfy the requirements could not be done within the 6 months. Of course, if the government really want to, if the person really want to operate a private columbarium, they can actually get started with all the necessary work well in advance. I'm sure the bill can certainly help facilitate these private columbaria so that the operator may now consider how they will be able to comply with the requirements in future, rather than continuing with the operation now and wait until 6 months have lapsed before they will, do what is required in order to comply. Of course, we would need to be fair to all the consumers and the relatives of the deceased. So I don't think we should wait until after the board has been set up before the operator consider doing all these things. And because of that, and when the bill, come up with this provision for a reasonable excuse, what are the scenarios under which the licensing board may accept as a reasonable excuse, other than the government department, being too slow? What other excuses might there be? Thank you, Dr. Chan. I think for such provisions, they are found in many other ordinances. Of course, the power would rest with the licensing board. How the board will decide will depend on the evidence. But if one looks at other ordinances or how other boards operate, let's say if it is not due to the fault of the applicant, then that could already be a reasonable excuse. I wouldn't use the excuse of the government department being too slow. But anyway, if it is not due to the fault of the applicant itself, resulting in the delay, that would be a reasonable excuse. I think this provision allows the licensing board the room to consider such applications made out of time. Well, my impression is that sometimes you do need the flexibility for any application procedure. And eventually, it should be for the board to interpret and to consider the grounds provided by the applicant. But if it is put in a very abstract manner, then it's possible that I can give you an excuse, and the board will require additional information from the applicant, and then the whole process will become very protracted. The operator may need to take a long time to explain why he has a reasonable excuse. So could you also consider whether for the reasonable excuse you should provide for a time limit? If the operator continues to come up with excuses after 6 months, then it could all go on and on. P.S. Would that scenario arises when the applicant will keep on, putting in so-called reasonable excuses? I think the answer should be that under such circumstances, the applicant doesn't have the incentive to stall, because with the commencement of the bill, if it fails to get the license, if he doesn't get the license, he can only operate the columbarium, but he cannot, lease out the niches or conduct any transactions. So my guess is that the intention here is that we want to have a time limit so that the operator can comply as soon as possible. We believe that there should be incentives for the operator to ensure that he complies with all the requirements. Otherwise, like what is the situation now, if he is applying for a license at the same time and selling niches at the same time, that won't be allowed once the bill becomes law. Let's consider the perfect scenario. For whatever reasons, let's say the operator said, tell the consumers that we're still applying for a license. Even though they're not allowed to sell niches, they can still, engage in promotion and so on. But before approval is given, can the Columbarium continue to operate? They can continue to operate, but they cannot sell niches. They can continue to collect management fees. The Columbarium will still exist, yes. He is not allowed to sell niches, but that he may still incur operation expenses. And these are the gray areas. And let's say the operator is still in the process of applying for a proper license, and then the consumer may still need to engage this operator to manage the niches. So I think in certain areas we need to, send out a clear message. Well, in that case, shouldn't there be a time limit? I mean, the operator may not really satisfy all the conditions. And Chairman, other than the safety issues, for the rest of the procedures, we will allow them time to complete the procedure. We have the 3+3 mechanism. The 3 month time limit is the time limit for submission of application. We're not saying that we expect them to satisfy all the licensing conditions within 6 months. We envisage that quite a number of these operators will, during this period of time, apply for the TSOL so that they can have more time to ensure compliance. So this is how it's going to operate. I think we may need to consider whether the board will have a mode of operation so that it can say whether or not it will grant a license within a specified period. We understand that we cannot, likely allow the operator to stall. So certainly there will be a time limit. So where is the limit? So in other words, we hope that 6 months after the commencement of the bill, they would have put in the application, whether it's an application for a license or application for exemption or the application for the temporary suspension of liabilities. So these are the 3 documents which they must submit. So are you saying that within 3 to 6 months, the operator would need to submit such documents? If failure to do that would mean that they can no longer submit the documents after the deadline, unless they have applied for an extension. Mr. Chen said that, asked a question about reasonable defense. You have to consider that together with B. That is, the board will need to ensure that it is just and equitable. So we have to, trust that the board, in performing its duties, will follow the right procedure. So you don't think that the operator will be able to stall? Albert Chen, I'm sorry for being late, and my question might have been asked by other members already. But anyway, if that's the case, I will, go back to the papers. Regarding the issues which Clause 21 is dealing with, I think it all concerns the operator. And what are the concerns of the operator, and why you think he needs to apply? He would need to know what are the consequences if he applies for a license and if he does not. The government should stipulate this clearly. It's like the illegal structures in the village houses. Earlier on, the government told us that it's going to demolish all these illegal structures, but now you suddenly stop all the enforcement actions. So for your policies and your enforcement, and how does that relate to the new ordinance? The government must spell all these out clearly. Whether or not you are going to enforce later on, it remains to be seen. Like our Chief Secretary of Administration, who promised to take enforcement action against these illegal structures in the village houses, with people like Mr. Leung Chun, the government dare not take any enforcement actions. For the question relating to these Columbaria, I hope the government can give us a clear answer. That is, what would be the consequences if the operator apply and not apply for a license? If it doesn't apply after 6 months, how are you going to deal with this operator? And we all know that the whole question regarding Columbaria involved 3 hurdles. First of all, the license. Secondly, planning applications. Many applications don't satisfy the planning procedure. They may not be even on columns 1, 2, and 3 in the planning procedure. You may need to go to the town planning board and so on. And thirdly, the question of amending the lease. For many of the applications, they involve amendment of the leases. So please tell us clearly this. That is, you are talking about tens of thousands of urns in Columbarium. The site on which they're located are not licensed and so on. So if you're going to issue the operator a license, does the operator need to satisfy all the license procedures? Do they have to apply for change of the lease and also the planning permissions and so on? And if it involves the lease, what is the government's policy? This is very important. The policy is to ascertain the so-called illegal operator, whether or not they want to apply. I mean, in the battle at the town planning board is already a difficult battle. According to the current policy, if the operator has to apply, they have to actually pay a premium. So you must explain this clearly.
A lot of people don't understand the complexity and the importance. Should we be paying a land premium based on the land price now or the land price then in the future? You have to do explanation. If you don't tell us clearly now, I'm sure 90% of the operators won't lodge an application and the ordinance will become totally useless. So please answer my questions one by one, and perhaps later on you can give us a paper giving me all the answers that I want, so that we have a common understanding on the issues, or else we'll be open to all sorts of disputes. Thank you, Mr. Chan. And Chairman, Mr. Albert Chan is very concerned about operators not making an application. What will be the consequences? Well, the consequence can be very dire. We talked about exemption, license, TSOL, how they should comply with land, building requirements. We explained that previously. We can provide you with the information later. If they don't make an application, that means that they are operating without a license. As we explained before, if you look at Section 8 of the bill, if the operator doesn't meet with 8.1, that is, it is operating without a license, and 2, if he continues to operate without a TSOL, he is already committing an offense. And if he is convicted, he will be subject to a fine and even imprisonment. If he doesn't make an application, if the bill is enacted, the FEHD has the power to enforce the law. We want to ask them to make an application ASAP. If that is done, then other government departments will not take enforcement action for the time being. If the operator doesn't make an application, well, apart from the FEHD, other government departments can take enforcement action against him as well. So if he doesn't make an application, other government departments can take enforcement action against him. Yes, but that's contained in Part 10. Can the administration give us some information later on as to which government departments under which laws will take enforcement action? And the time limit is not long either. There is a transitional provision. Well, it is found in many other laws. There is a grace period after the enactment date. The grace period is usually very short. Say, for example, 6 months after the gazetto of the law. And there are also provisions relating to appeal cases. So there are provisions relating to grace period. Schedule 7 lays out the transition arrangements, and after the deadline of that, then enforcement action can be taken. With regard to land premium, while planning, land requirements have to be met, they have to pay the land premium in full for both the non-pre-bill columbarium and pre-bill columbarium. Lands Department, can you tell us, to your understanding, after the enactment date, what is the land premium policy now? How do you calculate the land premium? Thank you, Mr. Chan. With regard to land premium, paying land premium, whether it's columbarium or not, it will be calculated based on the land price then. Well, for Union Monastery, well, the land premium is $150,000. So, well, if the land premium is that high, no operator is willing to pay the land premium. Well, they've sold off 90% of the niche spaces, and they're selling off the niche at, say, $50,000 or so way back, and you're asking them to pay a land high premium. Well, they were definitely not going to do that. So they said that the land premium will be calculated at the land price at the time of the application. Well, the operator has sold off 90% of the niche spaces. Who is willing to pay the land premium? Well, we are aware of what Mr. Chan talked about, and perhaps later on we can furnish you with further information. Well, don't do it later. This is so very important. Whether the law can be enforced depends very much on how the mechanism is going to work. So don't come up with grand provisions, and then you have difficulties in enforcing it, and leave it to the Lands Department to enforce the law. I respect the Lands Department, but then if you look at the policy at this point, it doesn't work. So, Bureau, can you talk to the Lands Department on this particular point and deal with this issue before you enact the law? If that issue isn't resolved, I think the law will be meaningless if it is passed. If we have to pass the law, we have to look at the feasibility of enforcement. I think this is a very constructive suggestion and idea. This is very important. Who is willing to pay the land premium? And ultimately, we will be ending up with the government shouldering all the problems arising. Well, Mr. Chan, you can wait for the next round if you want to follow up. Sorry, Chairman, will there be a paper after the meeting? There are 3 government departments taking care of all these matters. Will there be a paper? Will there be a timetable? A lot of the operators don't understand what is going on here. Chairman, can I give a brief response? Under the new law, we are very clear about this. For the dated Columbaria, we hope them to stay and continue with their operation. So in the design of the bill, we allow for exemption for those very dated Columbaria. To deal with these dated Columbaria with a lot of interred ashes, with regard to exemption and land premium, we do have discretionary power. And to a large extent, we would be allowing Columbaria with exemption status to continue with their operation. Concerning those who need to pay land premium, they are those who need to obtain a license, and with a license, they can continue selling the niches. That's another category of Columbaria. While those on exemption, then we will be dealing with them flexibly with regard to payment of land premium. Now, for Columbaria, which can continue to sell their niches, then, well, the price range is very large. The concept of the bill is that, well, under that circumstances, that they should pay the full land premium. I don't think after hearing what you said, we are still not in a very, don't understand clearly what you're trying to do. Let me make myself clearer further. For columbariums which existed before 1990, these are dated columbaria. Some of them have a lot of interred ashes in their niches, and they haven't paid any land premium at all previously. If they apply for exemption status, the law will allow the lands department to exercise discretion to waive the land premium so that these columbaria can continue operations. Let me supplement. In the council, in the LegCo brief, we mentioned that for exempted cases, while the columbaria must be those which operated before 1990, and if the niches existed before 8 a.m., the 18th of June 2014, then the lands department can also consider whether to waive the land premium. I think we need a written paper on this. Mr. Chan talked about $30,000 versus $150,000 now. So this is a real issue for the operators. You mentioned about discretion. Well, sometimes people are unaware of what discretion means. So you said that there may even be a waiver of the land premium. So I think you must make yourself very clear on that point. I'm sure that he has received some complaints in this regard, or else he isn't aware of this issue. Different operators have different financial situations. Sometimes the finances situation of an operator is not known. So how can you consider using or not using your discretionary power? For Columbaria, which plan to continue selling niches, they won't be able to get the exemption status. The exemption status is for really dated Columbaria, which have existed for a long time, and all their niches have been filled. And we all agree that for these dated Columbaria, we would try to allow them to stay on as much as possible. And against this spirit, we would be very lenient in terms of the land premium payment. We won't even rule out waiving the land premium altogether. So we can give you a written response later. This is something that I want to emphasize. Well, if we don't do that, we won't be able to resolve the issue. Mr. Leung Chi-Chang. I would like to respond to Mr. Chen's question. Maybe he is not very well versed with rural issues. Mr. Lau Wang-Fat has caused a short in rural areas usually. There are two issues that I would like to discuss in detail. First, about the application for exemption. For operators with a long history, while they may furnish all the information you need, and ultimately their exemption application has been rejected. And you said that you would be dealing with them using your discretionary power. Then if their application is rejected, then it's going to be very problematic for them. And some operators actually have been rejected a license, as far as I know. How do you deal with cases for applying for exemption status and their applications are rejected ultimately? Second, I would like to raise a question on Section 9. Section 8 has to do with an offense, and Section 9 says, Section 9, 1, what is a contravention is the person who's the owner, tenant, lessee, or person in charge of the columbarium can be found liable if you don't have a license and then you put the ashes in a niche, then you are committing offense. Except that if you know that if you are not aware or do not know whether the premises concerned were a licensed columbarium, well, this is very problematic. This means that if we are going to lease a niche in a columbarium, we will ask for the full set of information from the columbarium.
There may be some problems during the course of application. And so how can, like the restaurants, or we're talking about Columbaria which already exists, but for new Columbaria, well, there is a timetable for application. Would it be like the restaurants where the applicant can apply for a temporary license so that at least they have a chance to be in compliance? Why don't we ask the government to answer the question? Under the proposed legislation, we would allow those operators who are in the course of applying for a license to also apply for a temporary exemption, and that exemption will allow him time to rectify whatever problems would need to be rectified. The TSOL also has a time limit. According to the bill, the limit is set at 3 years, and there could be another. It could be extended for further 3 years. Chairman, I asked my first question. That is, if the operator cannot succeed in applying for an exemption, well, in that case, I'm afraid those columbaria will need to have to be closed down. Well, under the bill, we have a section dealing with these columbaria which need to be closed down and what procedures would need to be, carried out. Of course, we expect that the operator would, first of all, do his part and locate the relatives of the deceased and take back the ashes. If he has gone through all the procedures and not all the ashes could not be properly taken care of, there will still be a set of procedure for the FHD to take count of the ashes, and eventually we will place the ashes in a temporary storage premises. So this is how we propose to deal with that. So in the bill we do have arrangement for that. Of course, the procedure, I think what we expect is that the operator would do his utmost, and if he has done his utmost and he still cannot, properly take care of all the niches, then the government will step in. I like to emphasize the operator has this obligation. If he doesn't, perform, discharge his responsibility, then he will be in breach. Well, according to the bill, if the operator does not take proper care of the issues, he will be in breach of the provision, and there will be a penalty. There will be a fine, and also he may even be imprisoned. I'm talking about those who are operating Columbaria before this bill becomes law. So if he doesn't get, if the application fails, he will need to close down. Will he be penalized? You still invoke the new ordinance. Well, Mr. Tang asked a question regarding clause 9B. That is, if the owner or the owner, the lessee, and so on and so forth. I think this is very common in other ordinances. The building ordinance is drafted in a similar manner. We also have, such provisions which have been successfully enforced before. So we believe that the present provision can also be enforced. Dr. Helen Wong, followed by Ms. Sito. I would also like the department to explain this. That is, for Columbaria, which existed before 1990, they can apply for an exemption. Whether or not they get the exemption depends on whether or not they are in compliance with the current legislation, such as the fire safety and the land ordinance. So I have two questions. First of all, please specify clearly for those Columbaria which are blatantly, obviously in breach of fire regulations or the DMU, deed of mutual confidence, the DMC. There are many such instances in Hong Kong where the operators operate columbarium in private tenement buildings, and they place many of the urns in a private domestic tenement. And if they were to apply for a license, it wouldn't grant him a license anyway. And you told us that for these premises you will take enforcement action. So will you be invoking the new legislation when you take enforcement action? And do you expect that once the bill becomes law, you will immediately take enforcement action? What are you going to do? Or is it the case that you still won't be able to take enforcement action and these non-compliant Columbaria will continue to operate? First of all, on the question of exemption, of course, these Columbaria would need to have been in operation before January 1st, 1990. There are other conditions as well under the bill, including, for example, the requirement that they would not be allowed to sell the niches after June 18, 2014, 8 p.m. You mentioned Columbaria, which operate in multi-story tenement buildings. So of course, the operator would need to apply, but why you say that they may not succeed in getting a license, while they would already have breached the deed of mutual covenant already. For a single staircase building, they may not be able to satisfy the requirements. And thirdly, regarding enforcement, when the bill becomes law, and if you go to the bill, you find that we have delegated the director of the FEHQ to take enforcement action. There will be a clear, detailed explanation about this when we come to that clause. But it's whether or not these illegal Columbaria will be immediately, eliminated. I think in Schedule 7 there are provisional provisions, and it's only after the grace period had expired that the government will take enforcement action. Well, please tell us clearly this, that is in private tenement buildings where for Columbaria operating in private domestic premises. You told us that it's possible that they might get a license. So could you tell us why they might have a chance of getting a license that is operating a columbarium within a domestic premises? Could the Lands Department and the FST also tell us why such operator would be in compliance? I mean, and why are you making a distinction between single staircase and double staircase buildings? I think we've discussed this issue many times before. We're now into the clause-by-clause scrutiny of the bill. If you want to revisit these issues again, I think they've already given us the answers. So is it the case that these non-compliant columbarium can still get a license? Well, I think we should follow the arrangements as stipulated in the bill. Chairman, I don't think we should, go back to the macro issues again, because if that's the case, we will not be able to complete our clause-by-clause scrutiny of the bill. Well, questions about non-compliance with the data mutual covenant and so on. There are many factors involved, and I think they've answered the same question many times already. Now that you bring up the same question again, we'll be revisiting old grounds already. I think if you go back to the minutes of this committee, you would find that we've already covered those issues before. Otherwise, I think we should. Okay, I'll ask the government to give a simple answer to the question again. For the private columbaria that Dr. Wong was referring to, if they were to obtain a license, it's difficult for them to get an exemption because they were not been operating before 1990, and they would not qualify for an exemption. If they were to apply for a license, I believe we cannot say categorically that they will never get a license. But for the majority, I would say that it would be difficult for them to get a license, and it will be difficult for them to satisfy the requirements. But I cannot categorically say that for 100% they will not get a license. Well, there are building requirements and so on. I think we've discussed those issues, quite thoroughly before. Ms. Wong? He said that that the operator might get a license. Hence my question. I don't think any government official can give you 100% categorical assurance. Otherwise, I believe it's difficult for them to give you such an answer. But to respond to Mr. Wong's point, for many of these buildings, they were built before 1990. How is it that that it's not possible for these columbarium to have existed before 1990? There are quite a number of those, actually. I'm saying that if they were not in operation before 1990, they would not be eligible for an exemption. But if they're applying to continue with the operation, they have to satisfy or comply with many of the regulations relating to building safety and so on. So if we follow all those rules strictly, then it is the case that it will be difficult for them to really continue with the operations. So when I asked my question regarding fire safety, I was also thinking of the old tenement buildings that Dr. Wong referred to in her question. Let me follow up on Albert Chan's question. Just now, the officials from the Lands Department told us categorically that the premium will be calculated according to the level as prevailing at the time of the gazetting. But if the urns were not sold in 1990, they could have sold the first batch in 1990, and since then they have been selling the niches all along. And the price of the niche could be $150,000, whereas it was only a few thousand, 15 years ago. So you must explain to us how the premium is going to be calculated. Either you will say that for those which enjoys the exemption, they don't need to pay a premium, even for the operator, if he succeeds in getting a license, he would have the incentive. That is for niches which have not been visited for a long time, and which they have sold for a few $1,000s, they can evict the occupier and then retrieve the niche and put them on sale again. So you must. I understand that we are caught in a very difficult situation because you don't want to see private columbarium operating in private residential areas. But we must also recognize that the ashes of many of the diseases are placed on those premises which need to be taken care of. So please tell us clearly what exactly is your policy. I mean, if eventually you need to take over all these columbaria, why don't you get started earlier, so that for those columbaria which will never stand a chance of getting a license, you should eliminate them as early as possible. Why don't you start that process earlier so that people will not have any false expectations? Yes, I think Ms. Ho is right in saying that we are indeed caught in a very difficult situation.
We will try to deal with our problem out of historical legacy as much as we can. There are practical issues to be dealt with. There are different elements in the bill to cope with those situations. For those columbarium which have existed for a long time, we believe that the design of the bill is such that we can allow them to stay on as much as possible. As for the land premium, well, it involves even broader considerations. Let me emphasize once again that if our focus is on the columbaria, which have existed for a long time, and if they can get the exemption status, and the land premium will not be a problem to them. If they don't get the exemption status and they want to continue selling off the niches, then the Lands Department's colleagues will look at the revenue that is going to be generated. And the present land premium policy applies not only to columbaria, but as other uses, commercial spaces for commercial uses. Let me say this once again. For those columbarium which have existed for a long time, we do allow them to stay on, and there will be discretion to be exercised with regard to land premium payment. Ms. Sit Ho's question is really on whether you do have a clear formula on calculating the land premium. Do you have it or not? I'm afraid that I would like to defer to the Lands Department colleague to explain. I don't expect an answer today. I believe that the government will find such information sensitive and they will not make it open. Well, there will be two extremes, the impression that I get so far. One is a waiving of the land premium, and then the other is the land premium calculated on prevailing land prices. Now, if you adopt these two extreme approaches, then it's going to be problematic. Also, niches may be vacated for selling off again. But then if you've got the license given to them, you will not be in a position to know how they are selling off the niches, how are going to sort of keep a close watch on this. Well, these are not two extremes, Chairman. For columbaria with a long history, they may have old facilities as well as new facilities. For niches which have been sold off a long time ago, I believe that they will apply for exemption for that part. For new facilities, perhaps they may have new land which have not been developed. They would like to get a license to operate and sell off the niches. I'm afraid that they will have to pay a land premium for that part. So it's not like what you envisaged or mentioned. For the parts which have been sold off some 2 decades ago, they can choose to apply for exemption for that part. For other parts which have not been sold off yet, then they may choose to apply for a license. And if they do that, then they have to have to pay a land premium. The Lands Department, as I said, can exercise discretion and can even waive the land premium altogether. But, well, please discuss among yourselves first and then give us a paper later on. Let me supplement, Chairman. Will the operator evict existing niches for waiver of land premium? Actually, the FEHD took a snapshot at the bill announcement time. And the exemption was really to benefit the users and not the operators. Now, after the snapshot was taken, and if a niche was vacated or evicted, then the operator could not sell that niche off. They were not allowed to refill the vacated niches. Now, after the bill is enacted, there will be a clear contracts to be entered into, and the consumers can be protected. They would not, say, be evicted arbitrarily. So, well, and also we require the contracts to be written out clearly. Mr. Albert Chan, I hope that in your written paper, the administration can give us more details and more information. There are different types of operators of Columbaria. Some are charity organizations. Some are just an ordinary type of company. Some are non-profit making companies. And they are not totally charitable in a sense. And some have to do with monetaries, and the management may be in a chaos. And once the leader is changed, and then the management may change. Management style may change altogether. With regard to land premium, you have to be very fair. I may not totally agree with your approach of a total waiving of the land premium. So we have to look at the actual circumstances. We have to treat the operators fairly. Maybe some companies are pocketing a huge profit and they're taking advantage of the government's policies of a waiver, and they have to shoulder certain moral responsibilities as well. So we should not be having a rigid policy and as a result cannot deal with the issues on hand. And then ultimately the law will exist in name only because of this rigid approach. So PAS, please proceed with subsection 4. As we explained last time, when we talked about section 19, we talk about plans. And some members asked why plans are included in the principal legislation. If we look at subsections 4 and 5, you will understand why we attach so much importance to the plans. Section 19, we talk about plans provided in general circumstances. And here we said that apart from plans provided pursuant to Section 19, they have to, together with the application for a specified instrument, provide plans related to Section 3, A, B, C, D, E, F. They must show all the particulars in the plans provided in subsection 4. and they must identify the extent, if any, to which the particulars to be authorized or permitted as referred to in Section 19 differ from those as referred to in paragraph A. So when the licensing board approves the plans, well, the plans that they are looking at will be those which give all the information needed. Subsection 5 has to do with Section 20. And that section talks about the approval for the plans. And the licensing board must decide on certain information to be provided for in the plans. And we are talking about A and B here. What is the difference between this and Section 20? A is for the extent of unlawful occupation of unleased land as is necessary for or ancillary to the operation of the columbarium. When an operator applies for a TSOL, the operator is required to make an application for regularization of the unleased land. So for the TSOL, we would note down the situation prevailing at the time of the application. And when they have made an application, they would already have regularized the disorder, the irregularity. And B, structures certifiable for a pre-built columbarium. As we explained in the license and exemption situation, in Schedule 2, we talk about how we deal with those scenarios. So if they have applied for exemption or a license, if they have works going on, these will be shown in the plans. Well, we would try to contain the situation so that it will not worsen. So this is the arrangement for them to present the evidence that is in Section 21. So any questions on 4 and 5? Let's move on to Section 22. So this is another important section. It has to do with our notification scheme. Before I go into that, let me explain the background to these provisions. You may recall that the Secretary for Food and Health on the 18th of June 2014 announced this bill. And at the same time, he also announced this administrative notification scheme. And that was mainly to collect evidence. That is, the evidence at the time, the situation of the columbarium at the bill announcement time. So in Section 22, we provide for the procedures of the notification scheme and how we deal with the information collected. So after giving you the background, let me now go to 22.1. There are a number of terms in relation to the notification scheme. So we would first want to set that out clearly. And then from 2 to 4 is about the procedures and steps to be taken under the scheme. And then from 6 to 9, after we gather the information, we discuss, after the operators have lodged the application for specified instruments, how such information can help them with the processing of the applications. So these are the 3 portions to Section 22. After you know the structure, then it will be easier for you to comprehend this section. So 22.1 A to F, A is about the operator. Is in relation to a columbarium, means a person who operated, kept, managed, or in any other way had control of the columbarium. So this is the operator. B, eligibility related provision. in section 21(3), may I refer members to that section? And application for a specified instrument in respect of a pre-bill columbarium to which section 14, 15, or 16, and also section 4 of Schedule 2, for these provisions, under the notification scheme, the eligibility-related provision has the same meaning as that in the sections that I mentioned. Notifiable particulars, what are they? There are 2 batches. Why do we have to divide them into 2 batches? We have to be very specific and clear on the timing. Exactly at that particular moment, what is the situation of the niches leased or sold off? And we have to deal with the particulars in a very short space of time. We have to collect the information and then verify the information. So because of this timing constraint, and from the 18th of June to the 30th of June, we have all the manpower concentrated on collecting information on interment. And also there are other ancillary facilities. For example, they have furnaces for burning offerings. These are very common facilities. Furnaces are relatively easy to deal with. So apart from in batch 1, we also look at furnaces. But then there are also other facilities of all types, and these are necessary for their operation. So in the second phase, before the 31st of August 2014, we've also sent manpower to the operators to gather information on the ancillary facilities. So what are them? These facilities, well, they come in all shapes and sizes. For example, toilets. And for D and E, these are information or particulars collected at that particular juncture. This is a snapshot look at the situation.
Licensing board will consider that, of course. Let's say if you told me that you have 20 toilets, the board would need to make a judgment as to whether or not that is acceptable. So for D and E, that is in respect of the information under batch 1 and batch 2, we will try to ask the operator to provide us with such information within the specified time limit. Our colleagues will go there to take photos and verify such information at the time. And then we come to F, which is the background we talked about earlier. That is the 18th of June 2014 when the Secretary made the announcement. That is that the scheme is the administrative scheme. And for 1 and 2, it explains what the director will do. First of all, under 1, the director of the FEXG or public officer authorized to act for the purposes of the scheme to ascertain the notifiable particulars in the manner described in these subsections. And the relevant details are found in subsections 2, 3, and 4. Bracket 2. In facilitating in the manner described in subsections 5, 6, 7, and 8, the determination of whether any notifiable particulars are proved for the purposes of an application for a specified instrument in respect of a pre-bill columbarium. So this will assist the licensing board to deal with the licensing arrangements. And I will come to subsections 5, 6, 7, and 8 in a while. So having explained the terminologies, We'll now move on to subsections 2, 3, and 4 under the notification scheme. How do we proceed with the scheme? Under subsection 2, you'll find that under the notification scheme, the operator of the pre-bill columbarium must, under A, provide to the scheme officer, which is defined in the earlier provision, in the number of copies and prepared in the manner as the scheme officer determined. First of all, a statement of the notifiable particulars, and if an officer decides that the operator must provide records for these notifiable particulars, then under subsection 2, we may require them to do so pursuant to subsection 2. B, to give consent to the scheme officer to enter into the columbarium during the following periods: to verify the statement and the records provided by the operator for batch 1 particulars, the period beginning at the bill announcement time and ending on June 30th, 2014, and for batch 2 particulars, the period beginning at the bill announcement time and ending on 31st August 2014. Subsection 3, when the scheme officer entered the columbarium and verify the statements of the notifiable particulars and the records, the officer may take photos and take necessary records. For example, we may draw a plan of the premises to mark down the land occupied and so on and so forth by the columbarium. Subsection 4. After we've completed the compilation of records, the scheme officer might, if he or she so desires, prepare the following in duplicate. So one set will be given to the operator, and we will keep the other set. And these are actually, and they include the statement of the notifiable particulars, including the records and the photos relating to the notifiable particulars, including plans to indicate the locations of any facilities. So we will compile a set of records. One set will be given to the operator, the other we will keep. So the information pursuant to subsection 4 will be used by the licensing board in making its decision. So in respect of subsection 2, 3, and 4, regarding the particulars pursuant to the information scheme, any questions? Sito. I really am puzzled. Now, first of all, 20(1)(f), you refer to an administrative scheme. And what exactly is this administrative scheme? Is it legally binding? And then when I come to bracket 2, I'm even more puzzled. We're now in 2015. Today is the 17th of April. But in your bill, you already say that the operator under this notification scheme should have on the 30th of June and the 31st of August last year, you would need to comply with this and that. The bill has not yet come into force, and you already had such powers. Why is that? Because the bill has not come into effect yet. So if the applicants don't agree with your requirements, they are not in breach of the law. But some of the rights are not being are deprived of them. You may not allow them to apply. No. Now let me explain up to subsection 9. So even if the operator doesn't participate in the notification scheme, it doesn't mean that the board will not consider this application. I will explain in a while, under such circumstances, how the board will deal with such applications. I will explain that in a while. Since you have a way to deal with it after the commencement of the bill, why do you also have arrangements prior to commencement? Well, when the the bill becomes law, we would have all the authorities to deal with the license applications. But let's not forget that at that time, the community want us to resolve this issue as soon as possible and to actually contain the problem within a certain extent. And also when the details of the bill have already been announced to the public, and we don't go to collect the relevant information, the so-called open window will simply continue, especially with exemptions. Many people may want to apply for exemptions, and people would make use of that, window. So if we have to wait until the bill becomes law, then the problem might have deteriorated a lot already. I think here we are talking about a major principle here. We're all concerned about the so-called open window, people jumping the gun and expand the scale of the operations before the bill becomes law. While that is true, but I am a bit worried that, before the law becomes law, that the bill becomes law, everything is already, decided already. But if you do not spell them out, and if we continue the clause-by-clause scrutiny, it would really be problematic. Well, they have the administrative scheme. It's like the URL. You want to, take a snapshot of the people living in certain buildings. Since you already have the administrative scheme to take a snapshot of the situation at a particular moment. And the Permanent Secretary told us that under Clause 9, he said that other than subsection 2, there are other ways to deal with this. I'm rather worried that you are including things into the bill, things which already existed prior to commencement of the bill. Well, we need this freeze because after the commencement of the bill, we will give these pre-Columbarium, bill Columbarium some accommodation. Or for new Columbarium, they will certainly not be entitled to such accommodation. So we must take a photo for that purpose. Otherwise, during the open window, the problem will simply deteriorate. I think Ms. Sito is saying why there is this state. Now, let me explain further. Indeed, well, I must emphasize that the notification scheme but it doesn't mean that all the Columbarium operators must choose to give us the information under this scheme. They can choose not to. And I think this is Ms. Ho's question exactly. If the operator chooses not to give us the information, you can imagine we don't know when the bill becomes law. Assuming that it will become law in 2016, that would already be more than close to almost 2 years before we announced the bill. So to ask the operator to prove at that time to the licensing board that back in 2014, on the 18th of June, my Columbarium already existed with X number of niches. If he had not participated in the notification scheme, then we have reasons to believe that. Well, it's not that he cannot prove to the licensing board, but it will be difficult for them to prove that to the board that 2 years ago he already had all these things in place. But if he has joined the notification scheme, then we would have our officers taking a record of such information and the photos that we've taken and the information that we've taken record of and submit them to the future licensing board to help the board determine whether the operator indeed was already in operation back in 2014. So this will serve two purposes. Number one, we can freeze the problem, and secondly, we can help the future licensing board to determine whether the Columbarium in question already existed before the bill becomes law. I think that is our intention. I think if you say in the bill that if the operator had provided us information during the specified period of time, then he can opt for one method of application. If not, then there will be another way for him to apply. Here you are prescribing what the operator has to do. You're placing the responsibility onto the operator. I'm not comfortable with that. In English, you use the past tense, and that makes it worse. I think according to the administrative scheme, you need to take a snapshot. I think everyone knows that the new bill will be enacted. Everybody will need to collect information to help the government decide on the method of application in the future. I can accept all these administrative procedures, but if you put it in the bill and say that the operator has this duty to do this and that within a specified time, then before the bill becomes law, these things would already have come into effect, and nothing is retrospective. If the operator wants to go back, it simply cannot be done. So at the time you drafted the bill, you actually, refer back to a period of time which is already passed, and the operator cannot simply go back and. So in parent 9, if there are alternative method of application, then I think you should say that if the operator has joined the administrative scheme, this is the queue that you should join, or the procedure you should take. But the way you've drafted the bill is such that you are placing the responsibility onto the operator. But if the operator wanted to fulfill that responsibility, it would already have missed the deadline. When we made the announcement on June the 18th, I remember that the form that we gave the operator stipulated that it was voluntary. The participation was voluntary. Chairman, when we announced the bill, we already, based on information we obtained from the Development Bureau, we already had sent letters to all the known operators of such columbarium, informing them about the details of the whole scheme. And we also appealed to them to participate in this scheme. As my colleague said, this is all voluntary. It was a voluntary scheme. But if they have participated, and then the benefits are that in the future, after the commencement of the bill, it can help them, the operator, prove that.
The benefit is that certain things existed at a certain juncture of time. If the operator has not ratified any building or planning problems, then, well, things will be the way they were, irrespective of whether there is this notification scheme. There's no loss on the part of the operator. Well, if he didn't participate in the scheme, it is just that it would be more difficult for him to present the evidence. And we must agree that we must have a time limit, and we must take that photo, or else we'll be having problems with this window, so-called window period. So after considering all these factors, we launched this notification scheme so that it's easier for us to present the evidence in the future. We don't have any problem with the aim and the procedures. We needed to do a certain freeze of the situation. What I'm concerned about is the drafting, the way it is drafted. You have a retrospective effect, and that has already lapsed, and the parties concerned could not do anything now. So if you could draft it in a way that there are two scenarios and there are two application routes, then that would allay my worry. Is there any way that you can do it through administrative means and not legislative means? Can you do that? First of all, the provisions will enable the operators to understand exactly how the procedures work, and they participate in the scheme with full knowledge of what's happening. Now, if we do it the way that you mentioned, there are two routes. Well, actually, if you read the provisions, we provide for these two routes as well. Now, the first is if they participate in the scheme, what will happen? And then the second route is if they don't participate, what will happen? If you look at 22(1)(f), and if they participate in the scheme, what information is to be provided? And 5, 6, 7, and 8 will be invoked if the operator participates in the scheme. Now, if the operator doesn't participate in the scheme, the licensing board can still consider the application, and that will be done based on subsection 9. Now, of course, if you participate in the scheme, then it will be easier for the board to consider your application. But then if you don't participate, then it doesn't mean that the licensing board will consider, but it's just the threshold will be higher. And the evidence the applicant produces should be of probative value comparable to the evidence referred to in subsection 4. So these are the two routes that the operator can opt for. I think Ms. Sid, who has made herself clear, please consider her suggestion when you go back. 2A. 1. I think I have some question on the wordings. A statement of the notifiable particulars. In Chinese, the rendition is 关于, and 关于 and 有关 are repetitive wordings. Can you improve on the wordings here? Try to make it more succinct. Chairman, I would like to say something about 2A. I'm not convinced, because we are talking about retrospective effect, and it may undermine the rule of law. I would consult my legal friends and see how it can be amended in the best way. You said you want to take a snapshot look. We agree to it. But then the way it is drafted is problematic. It can be a very bad precedent, because it sets clearly that there is retrospective effect, and the parties concerned don't have the chance to do something he should have done. Well, we understand your point. So, PS, please take us through subsections 5 to subsections 9 as well. Mr. Tony Chair, the licensing board can ask for all sorts of information and decides on whether to issue a license. When you talk about relevant information, plans and photos, will they be made accessible by the public? Have you any thinking on that? The public may want to look at the plans too. Well, I think we should tread carefully on that issue. Of course, if the applicant wants to have access to the information and to make revisions, then that's acceptable. But if a third party would like to take a look at the information, because we are talking about commercial information, then it's quite sensitive. Some operators may think that such information is commercial information. Unless we've got consent from the operator, we don't have any plan to make the information accessible to the public. It's not your information, but information provided by the operator to the board. Can that be made open as well, made public as well? You talk about future applications. Oh, you're talking. I thought you were referring to the notification scheme. Well, the provisions in the latter parts have provisions on the situation Mr. Tony Chair mentioned. I haven't read the provisions in the latter part, so I am concerned about the plans submitted by the operators. I think they should be made accessible by the public. Please continue, PAS. Sections 5 to 9. Subsections Section 6 to 9 apply to an application for a specified instrument in respect of a pre-bill columbarium. Subsection 6. Under subsection 4, we said that there is the photos and records to be prepared by the scheme officer. A statement or such photos under the notification scheme by the scheme officer under subsection 4 is evidence of the notifiable particulars in the absence of evidence to the contrary for consideration of the board. Subsection 7. To avoid doubt, the situation here is made clearer. Subsection 6 relates only to proof of the existence of the situation at a particular time. A is that it relates only to proof of the existence of the furnaces or any other facilities in the columbarium as at the bill announcement time. And B, subsection 6 does not affect the licensing board's determination of whether the facilities fall within the essential ancillary facilities referred to in other sections. And these other sections refer to the section on the definition of columbarium and also sections 2, 5b, 6b, or 7b relating to unauthorized developments and occupation of government land or structures non-compliant with the buildings ordinance. And 2, bracket 2, is on paragraph 8, bracket 2 of the definition of structures certifiable for a pre-bill columbarium. Subsection 8 states that if the applicant fails to prove to the board any notifiable particulars under subsection 4, then the licensing board can consider that the applicant has failed to do so. Subsection 9 states that if an operator hasn't participated in the notification scheme, then the licensing board may, in its sole and absolute discretion, consider evidence of the notifiable particulars other than evidence referred to in subsection 4. But then the applicant must satisfy that the license board that the applicant was precluded from participating in the notification scheme, and also the evidence he produces must be of probative value comparable to the evidence referred to in subsection 4. Any questions? Subsection 9, you use the terms sole and absolute discretion. Well, how come that it is worded like that? So the discretion lies solely with the licensing board. That's what it means. Mr. Paul Chair, based on subsections 8 and 9, well, it won't suffice if you have the specified instrument. But if in the absence of specified instrument, then you would not be able to be granted a license at all. Is that right? Well, the applicant may be in a very passive position. Well, it's best that he participate in the scheme. And if he hasn't done so, it would be difficult for them to present the evidence. It will help with his application if he participated in the scheme. If he hasn't done so, then he must satisfy that the licensing board that he hasn't participated in the scheme by circumstances beyond his control, and he must produce evidence of probative value. And if he does that, then the licensing board will consider his application all the same. It's just that the threshold will be higher. It's not the case that the board will not consider his application if he hasn't participated in the scheme. Well, my understanding is more or less similar to Mr. Chair's. The licensing board may exercise its discretionary power. Well, by that, I would take it to mean that it will be very difficult for the applicant to get a license. Well, if the applicant meets A and B, then his case can be considered. Mr. Chair, subsection A, the English version, may treat is stated the applicant as having failed to prove. May is a permissive term or what? Or is it must? May is not equivalent to must. Of course, that's what it means. But what is your legislative or policy intent? Well, I just follow the dictionary meaning. Well, that's what has been meant all along in the legal provisions. Well, of course, I understand the distinction in the meaning between may and must. Your policy intent is that may be equivalent to must here. Say, if the applicant can't furnish the information, then it's almost certain that the licensing board would not consider his case, right? Subsection 9 says that if the applicant hasn't participated in the scheme and produces evidence of probative value, then his case may not be considered by the licensing board. Mr. Porcher? Let me try to think it through further first.
Both subsections 8 and 9 are about the consideration of evidence. So I also need to, digest this, slowly. I think there are there's major issues here. For 8 and 9, you say the applicant has already supplied the evidence pursuant to subsection 4, then it can apply. But for 9A, I really have reservations about this because you require the applicant to prove to the licensing board that he was not able to participate in the scheme due to circumstances beyond his control. The way you draft it would suggest that he is compelled to participate in the scheme. If he doesn't fall under 9A, you can still disqualify this applicant. And after the commencement of the bill, the evidence provided subsequently will not be so strong compared with, for example, the photos that was taken, earlier. So that already would be sufficient ground to reject his application. But according to 9A, you want the applicant to prove that it's not that he didn't want to participate, but he was not able to. Chairman, I really have strong views about this point. I need to go back and think about this more thoroughly before I take this up further with the government. At this moment, I think the government should delete 9(a) here so that the preceding provisions will have retrospective effect. Retrospective effect should simply allow eligible persons to apply for exemptions, but You're requiring people to do things that they cannot do, and then you tell them that that he has to prove that he was not able to do it at the time. Let me explain our intention when we drafted the bill. I think we envisage a scenario which is that when we launch the scheme, the operator, let's say he was not in Hong Kong, he's been away from Hong Kong for a long time, and he was able to prove that he was away from Hong Kong due to sickness, and he was able to supply the information afterwards. It was this kind of scenario that we had in mind. I don't know whether or not by, whether or not this would result in further complications. We may need to go back and think about it further. I think bracket B, you say that that you may agree, but then you may not. So does a legal advisor also like to give us some advice on this point? At this moment, if you delete 9 bracket A, then I think I will feel a lot more comfortable. But even if you, if the evidence provided for under 9 bracket B, you can still challenge such evidence, so you don't need 9 bracket A to help you. Reject the application. Okay, we can certainly go back and think about this one. Will legal advisor also look into this point for us? Thank you. Mr. Paul Chair, under subsection 8, is it the case that if the applicant could provide the records or copies of the particulars, then the licensing board would not have the authority, or he would not be able to exercise the discretion that he may exercise? So I think the way you draft this subsection seems to suggest that logically, if the applicant has such a statement, the board would not have that discretion. And you use the word may and the word unless, and find it rather difficult to understand. Could the law draftsman also help us clarify this point? So unless the applicant could provide particulars, otherwise the licensing board may take it that the applicant has not provided sufficient information. That's what it means, basically. So are you saying that if the applicant provides such a statement, then the board will not be able to prove the fact? I think the Chinese translation does not tally 100% with the English version. If we look at the English version of the draft, you're suggesting that once the applicant could provide for a statement, then the licensing board will not have any authority to determine whether or not he cannot prove the fact. So he has to accept the statement as evidence. So does the statement have such a lot of value as a statement? I think if you look at subsection 6, it says that if you are able to provide the relevant particulars, then such particulars would already be taken as evidence. So if there is such an submission, it would mean that there's not much the licensing board can do, or the board cannot challenge the authenticity of the evidence. I think subsection 6 says in the absence of any contrary evidence. So subsection 8 talks about evidence. If he has submitted the evidence, of course, someone could provide, particulars or evidence to the contrary. And that is why in subsection 6 we have in the absence of evidence to the contrary to the notifiable particulars. So if there is a contrary view, then both will be considered. Does that answer your question, Mr. Chair? I don't know. But the way subsection 8 is drafted, you have used a double negative, which is rather hard to understand. Could you further improve on that in order to allay Mr. Chair's concern? And the PS referred to subsection 6. Could we use the provisions of subsection 6 to further improve upon subsection 8 to better reflect its intention? Could that be done? Okay, we certainly go back and think about it. Basically, I think we understand we know what the intention is. So do members have any other questions? Because it's now already 12:40, we will need to adjourn in 5 minutes' time. If there are no further points, then I will not be starting scrutiny of any of the next section. Kenneth Chan, regarding the notification scheme, we understand that some members are concerned. I want to be able to go back and think about it further. We will also consult our legal advisor and consider how this could be further clarified. In the LegCo brief, the administrative notification scheme was already announced in June last year. I understand that if one goes back to the situation at the time, I think the legislative intent at the time was that you wanted the operator to join the administrative notification scheme. It's not that there's not an option, but then it will be difficult. That is, if you want to operate the business as an operator of the Columbarium, you provided the operator with a deadline. So legally, although there might be some leeway, but in principle, but I would like to ask the question that is, I think you've already finished with the implementation of the administrative scheme, so you might now have a checklist. I think we discussed it last time already. It's already there, but they will not be making an announcement to the public. I understand that we had an early discussion. My impression is that there's still a small number of operators who still did not accept the administrative scheme. We received application from 140 operators. That's more than 97%. There were 11 who were not on the list. Of the 140 operators, of course, we need to take out a few of the operators who operated private columbarium and burial undertakers. So we're able to actually reconcile the figures with some of the operators by looking at the records. For some of the operators, we could reconcile some of the figures. For the others, we rely on their affidavits or statutory declarations. For those operators, well, we've rejected some of the operators. There is one case for which we want the operator to provide supplementary information for us. So the case is still pending. Ms. Ho would also like to ask another question, so I would like to exercise my authority to extend our meeting by 15 minutes. Ms. Ho, I have a similar question. my comments apart from my comments about the drafting aspects, I have a specific question. How many operators refused to allow you to take snapshots? Or were you not able to identify these operators, or did they refuse to be did not allow your officers to go there to take photos? Or there have been operators who did not participate. There were some who participated, but in the course of verification, we're not able to reconcile the figures, and subsequently they refused to make a statutory declaration. So they simply refused to participate in your administrative scheme. They gave us the information, but the information they submitted did not tally with our record. We asked them to make a statutory declaration, and they refused. Chairman, I'm worried that this is the possibility of this happening is very slim. But would there be some operators you were not able to identify or approach? They were not even aware of the whole scheme and joined the administrative scheme, and you only found out afterwards. But 9A, I really disagree with 9A, right? According to Dr. Kenneth Chan, Ms. Hope, so, what about your views regarding subsection 5 to 7? I was basically concerned about 9 bracket 2 and 20 bracket 2. You are placing the responsibility, and you use the term was to. And if 9A is still in place, my concern is still not allayed. 9A requires the operator to prove that they were not able to participate in the scheme due to, circumstances beyond the control, and you're placing the onus on the operator. So so yeah, we understand Ms. Ho's question. We certainly take it back and see whether we could, come up with some amendments. For bracket 2, you can amend the phrase was to and give a factual description. Let's say if you take this route, what would be the next step? If you don't take this route, then what would be the next step that you need to take? I think that would be a lot, clearer to me.
Any other member wishing to comment on this part? If not, then, well, I'll wrap up the discussion here. And the next meeting, well, scheduled for the 27th of April, 10:45 a.m. We will start with C3446, Division 4, Clause 23. AOB. No AOB? Meeting adjourned. Thank you for being here.